Hi guys, welcome to Commercial Law Tutorials, Law of Lease. We have already looked at the definition, requirements and the characteristics. We are going to move on to lesson number 2, types of lease agreements. In this lesson, we'll look at the introduction and then the types of lease that we have. While entering into a lease agreement with any landlord, tenants choose between residential and commercial leases. Those are the main two forms of leases we have. Residential leases provides tenants space to personally reside in, that is a home to live in. Then commercial leases gives a tenant the right to use certain landlord's property for a business or commercial activity for a period of time in exchange for money paid to the landlord. Commercial leases include hotels, office space, retail shops, and industrial buildings. Those are commercial leases. So commercial leases are for business reasons, while residential leases are for residing in. Whether the leases are residential or commercial, they can also be either individual or joint leases, or they can be subleased. So we are going to look at the individual joint leases as well as a sublease. Individual leases, only one person enters into a lease agreement with the landlord, for which he is bound by the terms and conditions in that lease agreement. It has a single right of exclusive possession of the property. In the case that there are more than two people that are living in the same unit, if they have individual leases, each individual will be having the individual lease agreement for himself and take responsibility only for their spaces or rooms. Each tenant pays rent separately to the landlord, each resident being solely responsible for his own action. So, even if there are more than two people living in the same place or unit, if they have individual leases, they will be having individual contracts. If there are 5, they will be having 5 lease contracts. Then a joint lease is one in which all roommates or all individuals in a particular apartment sign the same lease. They sign the same lease. This means everyone is equally responsible for all rules and regulations in that lease. They have a single right to exclusive possession of the property as multiple occupants, that is, they are joint tenants. For instance, university housemates, those are joint tenants. They have a joint lease. So in a joint lease, they have unit of possession, that is right over the same property. They also have unit of time. They would have contracted to possess the property at the same time. Additionally, they have the unit of title. They have a single lease agreement. And lastly, they have unit of interest. They have a single set of legal rights and obligations. Let us look at a sublease. A sublease takes place when a tenant enters into another lease agreement with a third party, a third person, to allow that person to use and enjoy the landlord's property in return for payment of rent to the tenant. So the tenant, after entering into a lease agreement with the landlord, goes on to enter into another lease agreement with another person, a third party. They enter into a sublease contract. When the tenant subleases the property, there are 2 lease agreements that exist, as we have been saying. There is the primary lease agreement between the landlord and the tenant, which continues to exist as he pays rent to the landlord as well as perform as expected by the landlord. Then there's the second lease agreement that will be that is the sublease agreement between the tenant and the third party, the subleasing. The sublease terminates as soon as the primary lease agreement comes to an end. But in the case that if the primary lease agreement between the landlord and the tenant specifically excludes subletting, if the tenant is not allowed to sublet and the tenant proceeds to sublease the property without the landlord's consent, the sublease is void. It will be a breach of the primary lease agreement and entitles the landlord to cancel the primary lease agreement between the landlord and the tenant. Having looked at all this, let us now move on to the types of leases we have. We have fixed-term leases, periodic leases, tenants at will, and tenants at sufferance. A fixed-term lease lasts for a specific period of time, has a definite commencement date and expiry date. For instance, 2 years, 3 years, 4 years. The tenant will be required to occupy the rental property for a specific period, and once this period expires, the tenant is required to vacate the premises except if the lease agreement is renewed. A fixed-term lease can either be short-term or long-term. Whether the lease one enters into is short-term or long-term depends on the state or country regulations. Short leases are from 0 to 10 years, while long leases can be 10 years to 99. And for some countries, all long-term leases are expected or required to be registered. We also have periodic leases. A periodic lease is for a recurring period of time. It doesn't have a fixed term. It has a commencement date, but no specified end date. Thus, it will continue indefinitely. The tenant is allowed to occupy and use the landlord's property periodically until the agreement is terminated by either the landlord or the tenant. For instance, month to month, week to week, or year to year. Those are periodic leases. Then we have tenants at will. A tenant at will arises when a tenant occupies a property with the landlord consent indefinitely, for which either party give an immediate notice at any time to end the arrangement. So it lasts for as long as both parties desire. But it is usually only suitable for temporary short-term use of the property. Next, we have tenants at sufferance. This refers to the period during which a person renting a property continues to live on that property after his lease has come to an end. The tenant keep on residing in the property past the time the term of lease has ended and gives the landlord rent. It usually exists because the fixed lease has expired and tenant may have chosen not to renew the lease but continue to reside on the property and pay rent to the landlord, or also when the landlord sends a valid notice to end the tenants because the tenant has violated the lease and tenant keep on staying on the property. That is also when tenants at sufferance may occur. That was all I had for you. Thank you so much for watching. Remember to subscribe and to like.